Hey, I'm Paul Rabalais, and in this video we're going to ask and answer 10 frequently asked questions about estate planning. You know, I'm a lawyer and most lawyers like to blabber, and I want to make this video a no blabber video. I'm going to jump on 10 questions, 10 quick answers. Yeah, I got a bunch of other videos where I go a lot deeper in answering some of these questions that we get all the time, but this is going to be fast. So here we go, and oh, by the way, this is I'm a lawyer in Louisiana. I help our Louisiana clients get and keep their legal affairs in order, and so some of these questions and answers are state specific. So if you live in another state, you may need to check with another source or another lawyer to make sure the answers to those questions are appropriate based on your state. All right, again, going fast. So here we go. Number one, 10 frequently asked questions. Number one, what's the difference between a will and a trust? When we get that question, most people are really asking me what's the difference between a will and a revocable living trust, because there's a lot of different kinds of trusts. So here's the deal. The traditional way to leave your estate to your heirs: write a will, leave assets in your name. When you die, assets are frozen. Your survivors come to lawyers like me. We got to guide the family through a court process because it's just been determined that our courts will oversee what's in someone's name when they die, whether they have a will or not. In order to avoid that probate court supervised process, many people transfer their assets to their own, what we call revocable living trust. And then the trust really replaces the will, because the trust dictates where the trust assets go when the person who sets up the trust dies. And so as long as those assets are in the name, titled in the name of your trust when you die, things in a trust don't go through probate. You'll name a trustee, kind of like you'd name an executor if you had a will. You'll name a trustee of your trust to handle that distribution of trust assets to your trust beneficiaries when you die, all done outside of court and attorney involvement. That's number one. Number two, what happens if I die without a will? Very Louisiana specific question. I can't cover every scenario, but I'll cover the basics. If you're single and you have kids and you die without a will, without any kind of legal plan in place, your stuff's going to go to your kids equally. If you're married and you happen to have some separate property when you die, your separate property will go straight to your kids. Your spouse will have no interest in that, but your one half of the community property, your spouse will inherit what's called the usufruct of that until your spouse either dies or remarries. Your children are what's called the naked owners to inherit that half of the community property when your surviving spouse's usufruct terminates upon their death or remarriage. Again, lots of estate planning gets done to deviate from those laws that would apply if you didn't have a will. Number three, do I need a power of attorney? Everybody needs a power of attorney. If you own anything, you need to have a power of attorney. And usually there's two types of powers of attorney. There's the financial power of attorney, because if you have an IRA, if you have an individual brokerage account, if you have a vehicle, if you have a home, and you get incapacitated, maybe you get in a wreck, you get sick, and you're not able to sign your name, and you don't have the capacity to understand what you're doing, if you don't have a power of attorney, then some family member of yours is likely going to sue you, go through a really difficult court process in an attempt to have a judge declare you incompetent and name them as the legal guardian. All that gets avoided if you have a power of attorney where you designate who you'd want handling all of your financial affairs on a financial power of attorney if you're alive and incapacitated. And then you'll also have what's called a healthcare power of attorney, where you'll designate who you want making your medical decisions if you're not able to make them for yourself. On all these powers of attorney, if you're married, you're likely to appoint your spouse, maybe an adult child as a backup. Always good to name a backup. Number four, do I need an estate plan if I'm not rich? I think the middle class needs estate planning even more than the rich people do, for a lot of reasons. Number one, we'll talk about it in a minute, but the middle class often gets kind of wiped out if they go into a nursing home, and virtually everyone needs to dictate where they want their things to go, whether they have $1 or $100,000 or $1 million or more. As Dear Abby said, whenever you want to get to know somebody, share an inheritance with them. So you need all of the power of attorney stuff to be able to, so that the right people can handle things if you're incapacitated. You need to designate your executor or trustee who will handle your estate when you pass away, and you need to designate where your stuff will go. So there are many, many reasons for people who aren't rich to have an estate planning legal program. Number five, does my will control my retirement accounts? Just about everybody these days has IRAs or 401ks with their employer. In general, no, the will doesn't dictate where that stuff goes. When you set up an IRA, you'll designate on the beneficiary designation form who gets those IRAs when you die. So that stays out of your estate unless, however, you happen to name your estate as the beneficiary on your designated beneficiary form. Then it does route back through your estate and through your will. But in general, that's rare. So the will has nothing to do with where your retirement accounts go. Number 6, how do I protect my estate if I go into a nursing home? Big issue out there, and the quickie answer, I could go on for hours about this, but the quickie answer is you got to get stuff out of your name, and it needs to be out of your name at least 5 years before you go into a nursing home. Some people put stuff in their children's names, but some people don't like that because they don't like the loss of control, and there's some tax reasons, such as losing the step up in basis if you leave it to them as an inheritance. And so there's some tax reasons not to put stuff in your kids' names, along with that lack of control of putting stuff in your kids' names. So many people put stuff into a very particular type of irrevocable trust where they are able to have more control, and some of the tax disadvantages of putting stuff directly into your children's names don't apply. So getting it out of your name at least 5 years before you go into a nursing home. If you go into a nursing home and if you own anything or if you've transferred anything out of your name in the previous 5 years, you're not going to be eligible for Medicaid. Planning while you're healthy is the key. Number 7, what's the death tax? Here in Louisiana, we don't, just a few states, handful of states have a state inheritance tax. We don't have one. It went away over a decade ago, but the federal government, the IRS, has an estate tax. However, for 2020, the first $11.58 million that one has is not subject to this 40% estate tax. Oh, by the way, that $11.58 million exclusion amount is going to revert in 2026 back to $5 million adjusted for inflation. So be aware of that. The estate, or what some people call the death tax, doesn't affect most people. Number 8, how do I keep my child's spouse from getting my money? Tough question. So most people leave their stuff to their kids. And again, a Louisiana issue, when you leave it to your kids, that inheritance that a child receives is their separate property. So it's theirs. And if they, the next day they get divorced, they'll keep their separate property, and they will split the community property that they've acquired with their spouse. One of the mistakes that children make when they receive an inheritance is they mix up, or the word is commingle, their inheritance with other assets that they have with their spouse. If they commingle the separate property with their community property, it generally all becomes community property. They lose half of it if they get divorced. You can, if you want to, take some steps to further ensure that your children's inheritance will remain separate, perhaps putting it in a trust for them so that it won't get commingled with assets that they have with their spouse. But that's the general answer on that question. Number 9, how do I keep from being on life support if I'm a vegetable? Sign a living will. Many people get all these terms mixed up. Last will, living trust. Living will is where you dictate. You get to make your decision. The patient gets to make all of their medical decisions. By signing a living will, you're making your life support machine's decision in advance. And in general, you're directing and telling your family and your doctors that if you're ever in that vegetative state and there's no chance of recovery and the machines are serving only to artificially prolong the dying process, by signing a living will, you've made your decision, you've directed them to honor it, keeps your family from having the burden of having to make that decision. Now, any other medical decision, that healthcare power of attorney that we talked about in number 3 really takes over. The living will really only applies when you're a vegetable with no chance of recovery. And number 10, how can I keep someone from contesting my estate plan? Well, maybe you want to consider inserting a no contest clause in your estate planning legal documents. The validity of your no contest clause, which would essentially say if any of my heirs contest anything, they get nothing. That's typically what it says. The validity of that no contest clause is questionable, varies from state to state. When it doesn't apply, it's because maybe some judge says, everybody is due their day in court. But so it's a state by state issue. But sometimes the existence of a no contest clause in an estate planning legal program is enough to keep that potential person who might contest from contesting. There you have it, 10 frequently asked questions in the No Blabber video. If you have more questions that you think are frequently asked questions, but I didn't address it, put it in the comments below. Click the subscribe button and the notification bell that comes along with it. Give me a thumbs up. See you next time.